sit down. Just sit down, will you? The House Families and Veterans Committee will come to order. Would the clerk please take attendance?
Chair Schmaltz,
Here.
Representatives Wozniak,
Here.
Fox, Johnson,
Here.
Thompson, Pavlo, Wolford,
Here.
Young,
Here.
Burns, Reingans,
Here.
Song.
Present.
Madam Chair.
Chair, Jamie Thompson is on Zoom.
Yeah, I thought Jamie Thompson and Aaron Burns were supposed to be on Zoom. I don't know if they're there. I didn't hear them say they were here. Okay,
Okay.
Madam Chair, you have 7 members present, a quorum.
okay, thank you. Representative Young moves to adopt the minutes of the June 24th meeting without objections, so ordered. Our first order of business is to hear testimony on House Bills 4676 and 4677. I welcome Representatives MacDonell and Representatives Wozniak. You can start whenever you're ready. From one committee to another, right, Rep. Wozniak? There you go.
My apologies,
Oh, no.
but you did sneak in front of me.
I did not. Just start your testimony.
Wow.
Oh, don't worry,
an
we're friends.
interesting
Don't worry.
committee. Okay, good.
No.
Hello, Chair Schmaltz and members of the committee. Thank you very much for agreeing to consider our bill package today. I'm partnering with Representative Wozniak. As the chair of the Michigan Legislative Disability Caucus, I have the privilege of interacting with Michiganders with disabilities and their families from all across the state. I hear about their triumphs, their struggles, and their dreams. And if there's one conclusion I can draw from all of their stories, is that no two people with disabilities are the same. The disability community is not a monolith. It is a beautiful patchwork quilt. Similarly, intellectual and developmental disability is best understood as a spectrum. Some individuals require around-the-clock care and supervision, while others live completely independent lives, and of course, most fall somewhere in between. Today, Representative Wozniak and I are before you with legislation that recognizes this fact by amending Michigan statutes concerning court-appointed guardianships for people with developmental disabilities. My bill simply requires courts to consider less restrictive alternatives to guardianships before appointing a guardian under the Public Health Code. Under my bill, courts will only restrict the freedom of people with developmental disabilities to the extent necessary to keep them safe and not beyond. Some of the less restrictive alternatives are options already recognized in Michigan law, like durable power of attorney, assistive technology, and trusts. My bill will add to those options with a concept that's new to Michigan law, but has now been codified in 29 other states. This concept is known as supported decision-making, or SDM. In supported decision-making, people with disabilities work with friends, family members, and professionals of their own choosing to help them understand their choices in specific situations. However, their support team's influence ends there as advisors. In other words, the person at the center of these arrangements receives help and advice, but ultimately they make their own decisions. In other states, this model has been shown to be an effective way for some people with developmental disabilities to live safely while not losing their rights. I'm honored to have with us today virtually Linda Van Wormer. Linda is a Dearborn Heights resident who fought for and won the right to use supported decision-making the first time in Michigan. Linda will testify with a member of her support team. I'm very excited for you to meet her and hear her story. Also, you each have a letter from Jonathan G. Martinez in front of you. Mr. Martinez is the national expert on supported decision-making. He helped Linda win the right to use SDM. Among other information in his letter, he cites a study that found people using SDM demonstrated increased independence, improved decision-making skills, and enhanced quality of life. Crucially, our bills do not end court-appointed guardianships for people with developmental disabilities. Far from it. Guardianships are necessary in some cases, but they should be used only when absolutely necessary for an individual's safety. Because when under guardianship, people truly lose their rights and freedom. If someone has the capacity to make certain decisions for themselves, they should not be deprived of the right to make those decisions. Our legislation simply requires courts to consider the full spectrum of people with developmental disabilities and the full suite of options that can help them live their lives with dignity. Together, House Bills 4676 and 4677 will be Michigan's next step forward in guaranteeing equal rights for all, regardless of ability status. Thank you very much. Now I'll turn things over to Representative Wozniak.
And once a person gets guardianship, it's hard to revoke it.
Madam Chair and members of the committee, HB 4677 makes an important and timely addition to Michigan's guardianship law by formally defining supported decision-making as a recognized alternative to full guardianship. Supported decision-making allows individuals, especially those with disabilities or age-related conditions, to work with trusted friends, family, or professionals to understand their options and make informed decisions without losing their legal rights. It is a practical, person-centered tool that respects autonomy while still providing necessary support. This change doesn't eliminate guardianship where it's needed, but it ensures courts and families consider less restrictive alternatives first. It promotes dignity, self-determination, and aligns Michigan with best practices nationally. Personally, I've spent a couple decades in probate court. I've seen many of the families that go in there be ignored by our judicial participants. This bill and 4676 allows for that person to have autonomy in decision-making and a priority list as to who can be appointed as the supporter. That means family members cannot be ignored. Judges will have a list of that priority list, of those priorities, so that they have to go through that list and make the reasons why that person on that priority list wasn't appointed. Not only that, but our judicial participants will be educated on this particular system. And the person being appointed many times comes in there ignorant of the responsibilities that they will have. They have to handle finances, take a person to the doctor, but they don't understand that at the beginning. I'm sure many of you who have never been in probate court would be surprised by what your responsibilities are once you're appointed to this position. It also makes for an easier system to terminate or change the position of the supporter, so that if they realize they're in over their head, they can say, hey, I just can't do it. And I think that's important for the ward, the participant that has a disability, to make sure that they're being taken care of and their needs are met, more importantly than any other thing that we're talking about today. Thank you.
Thank you so much, Representatives. I think this is a great package of bills. Serving on the Eastern Seattle State Board for a long time and Disability Connections in my area, it's so important that we make sure our disabled individuals have a say in what goes on in their lives. And you talk about dignity, and that's so important. So thank you for bringing these forward. Do we have any questions for the representatives? Representative Rigas.
Yes, thank you. Thank you so much for being here, both of you. My question is about the origin of these bills. Where did this topic come up? Was it your idea, or how did you hear about it? And how were people with disabilities involved in drafting and revising the legislation?
I don't remember. I think the group came to us and asked us to do this. The group that supports SDM It definitely came to our attention because of the Michigan Legislative Disability Caucus. And we've just then learned about so many other people and the other states that are doing this. And it's just so sensible because when you hear the story of Linda Van Wormer, you'll hear how unintentionally a guardianship can really become a prison for a person and keep them from doing what they want to do. So she has a great story to tell in terms of that. And as Sarah here said, how hard it is to get out of them once you get into them. And this gives another option.
And I might say, when the representative brought this package to me, it was such a priority in my mind that this needed to be done. With, again, my experience in the courts, the decision-making that you would get, say, in the metro area in Detroit is a lot different than what you get in Traverse City, and that's not fair.
Thank you.
Okay, we've been talking about testimony from Linda Van Wormer. Who? Oh, I'm sorry, Rep. Wolford, we'll go to you first.
Thank you, Chair. Appreciate you. So just a question, I get always concerned when I hear about courts and government making decisions on the behalf of an individual. And so can you tell me how this will help or hurt those maybe with a milder intellectual disability, if you will, guardianship, when it may not be necessary? And can the court come in and take their freedoms?
It's a great question, Rep. I will tell you that when you see, there are guardianship companies in our state, and they operate sometimes with 600, 700, 800 wards. Now, how do you handle that load? Do you pay attention to the ward? What's the requirement for visits? How does the ward feel when they're ignored, when their needs are supposed to be taken care of? And the family member is going to be important in this type of program. They'll be closest to the ward. They're the ones that can take care of them. But more importantly, in this program, the supporter is going to be educated as to what exactly they have to do with the court support. Now, we're trying to take this off the docket of the court, and it certainly will. And we're trying to do that with a few other bills, too, on guardianship. You know, the dockets are crowded in the judicial system, and it makes, like, when a judge gets a pile this high for one day, boom, boom, boom. So the attention that's needed for these type of cases isn't there. It's just not there.
Okay.
All right, I hope that answers your question.
It does. Thank you. Appreciate
Rep.
you.
Johnson.
Thank you,
Add to
Madam
that
Chair.
quickly. I just happened to speak to someone yesterday who's a guardian, and she was telling me about the guardianship package we were talking about, and she said, how could I ever visit all of my wards once a month? I have over 100 of them, and I'm thinking, well, maybe you shouldn't have over 100 people. So this just provides this opportunity to get real attention, real personalized assistance in your life, as opposed to just having someone making all of your decisions for you, people who don't even know you. So if people are able to do this, I think they should be allowed to do this.
Rep. Johnson.
Thank you, Madam Chair. I'm completely supportive of this, and our office has received many complaints about the guardianship situations currently. Does the judge make this decision? They decide whether they get an alternative
Yeah,
supported
the judge
decision?
would have to issue an order for this so that it's in the court system, but not on the docket where it'd be in a guardianship.
And so the judges are in favor of this, or what's their response?
Have we got an opinion
Last
from
we
them?
heard, the probate judges were opposed.
But that might not be surprising either.
But if you read the letter to, we have the letter from Mr. Martinez, you'll learn more about that.
All right, thank you. Thank you, representatives, for your testimony. We'll now hear from Linda Van Wormer and Amy Peckinpah on Zoom. They're joining us to tell about their personal stories. Go ahead, Linda.
We're going to start with the presentation. Can you hear us?
Yes, we can.
I'm Linda Van Wormer. This is my sister Amy Pecknog. Hello. So we're gonna start with the presentation.
Welcome.
Thank you.
This is Lincoln Van Homer. This is my story. I'm making a decision. I'm an aunt. I'm a sister. I vote. I have a brother named Brian. I work at Steps, and I have a disability. This is me at 7. I have support with my family.
They want to talk too. Okay.
This is me going up. This is me going up, and have support with my family, and my sister was shared.
Okay, so childhood and emerging adult stages. Linda was adopted at the age of 5. There are 6 siblings that are in the family. Linda attended special education classes through the age of 26. There's a picture on the bottom right of graduation day with our mom. And then Linda lived in an AFC home for a short time upon graduation. And then on my own with some supports, Linda lived with a boyfriend for over a decade with limited supports from the local community mental health program. And I served as Linda's payee for several years during that time. And then Linda's support needs changed. Abuse and neglect occurred. There were some choices that did not keep Linda safe and healthy. And so Linda moved in with me, moving from Northern Michigan to my house for 6 months in 2011 before she did self-direction with a roommate in Southeast Michigan. And at that time, I became her partial guardian.
This is me growing up with my family, and my sister will explain more.
Okay, this is Amy. Childhood and emerging adult stages. Linda was adopted at the age of 5. There are 6 siblings in the family. Linda attended special education classes through the age of 26, graduated, and lived in an AFC home shortly after graduation. On my own with some supports, Linda lived with a boyfriend for over a decade. She received limited services from the community mental health program in Northern Michigan, and I served as her payee for much of that time. And then the support needs changed. Abuse and neglect occurred. There were some choices made that did not keep Linda safe and healthy. She then moved from Northern Michigan to my house for 6 months in 2011. And after that, she moved in with a roommate and self-directed her supports and services. And at that time, I became her partial guardian.
Okay, does that complete your presentation?
Chair Schmaltz, sorry to interrupt. Amy's texting me saying that she is muted and cannot unmute.
Okay, now I'm able to unmute. No, you actually need to go to the next slide. There's 12 slides in the presentation, but I wasn't allowed to unmute.
We're working
This is
on
my
it.
story on partial guardianship. They said I was not gonna make decisions. And Amy will tell you the rest.
So we had to go downtown, right, Linda, to the city building, the Coleman A. Young Municipal Building, 2 times. The court referred to Linda as a ward of the court. They said she was incompetent, and they talked a lot about your deficits. They shared reports and the testing that they completed with the guardian ad litem, with the court officials, and this happened every 5 years. And as I served as the partial guardian, there were annual reports for me to fill out. And Linda indicated that she left those court hearings with half of her rights going to me. And I served as Linda's partial guardian from 2011 to 2021. That's 10 years, Linda. And at times, I saw that my sister really struggled with me making some of the decisions for her, or feeling like she needed to consult with me for decisions that she really didn't need to. And I did this because I did what was best for Linda, or what I thought was best for Linda at that time.
This is me meet with my lawyer with 4 POA.
Already signed papers. My family is has power of attorney over me. I could change it anytime I want.
So who's in charge? Is it the court?
Me.
Or you?
Me.
Watch my video. Watch this supportive decision video.
Here you got to click on the link that plays the WXYZ video.
This is living bedroom room.
The use of AI is exploding. A key enabler to deploy AI is networking.
By combining HP and Juniper, we have the potential to innovate in ways that our customers and our partners have never seen.
A Wayne County probate judge just made a historic decision. Instead of putting a Dearborn Heights woman under guardianship, he allowed her to retain her independence with something called supported decision-making. 7 investigator Heather Catallo has been exposing problems in Michigan's guardianship system for years. She joins us now with a look at this groundbreaking decision and how it could change the lives of vulnerable people in our state.
Brian, this is really significant. If you're put under guardianship, that means a court has declared you legally incapacitated. You lose the right to get married, decide what doctor you want to see, or even choose where you want to live. And now one woman with an intellectual disability has shown the courts that there is another tool families can use that's less extreme than guardianship.
Linda Van Wormer loves her job.
Keeps me busy.
The 56-year-old works at STEP, or Services to Enhance Potential, in Dearborn.
You put this right on top of this and do like that.
She also just made history in Michigan.
High five. Hey, leave me hanging.
All right.
That's because Wayne County Chief Probate Judge Freddie Burton Jr. just issued an order denying a petition that would have put Linda under guardianship. Instead, he granted her the freedom to make her own choices using something called supported decision-making, or SDM.
I do call the shots now.
And that feels good.
Yes, it does.
Linda has an intellectual disability. She was adopted at the age of 5 into a big family of 6 other siblings. Her younger sister, Amy Peckinpah, has always been one of Linda's main sources of help, support, and love.
I'm very proud.
Back in 2011, Amy found out Linda's boyfriend was abusing her. So Amy had to petition the court for partial guardianship of Linda.
It allowed me to say that Linda couldn't go back up north and live with her abuser. I had to make that decision to protect her, and so that is why I did that. But it meant I took that right from her. She couldn't consent to treatment. She couldn't decide where she wanted to move.
After 10 years of guardianship, Amy decided to restore Linda's rights. Linda now lives in a group home with friends, she works, and they use supported decision-making when Linda needs a little extra help.
Linda uses her family, her friends, and if she needs some extra input, she'll say, hey, what do you think of this?
Amy and Linda even hired an attorney to create estate planning documents so Amy can step in to make medical and legal decisions if needed. But late last year, a mix-up at Linda's mental health support agency prompted a social worker to petition the court to put Linda back under guardianship.
Now we're stuck in the system, and we have to actually go to court and now fight. And at that point, I was really angry. And I work in the disability community. I lost some faith in how are we doing this to people? It's not okay.
The agency quickly realized their mistake and hired lawyers and experts to help Linda fight the guardianship.
My favorite question when it comes to guardianship: what else have you tried? Before we decide to take rights away, shouldn't we ask that question? Rights are precious.
Jonathan Martinez is the Senior Director for Law and Policy at the Burton Blatt Institute at Syracuse University. In courts across the country, he successfully argued adults with disabilities don't always need the extreme step of guardianship. He says they can use supported decision-making instead.
For people with disabilities who have for thousands of years been assumed not to be able to do things, what supported decision-making is a way to be like you and me to the maximum of their abilities, because it says that people with disabilities can understand things if it's explained to them.
Linda and Amy say at first the judge was skeptical because there's nothing in Michigan's laws that establish SDM. But after listening to Linda and to experts, Judge Burton issued this detailed opinion, agreeing that Linda and her family can make decisions about her life together without a guardian.
I was so happy for me to get rid of that guardianship.
Hopefully it paves the way for other individuals with developmental disabilities to use supported decision-making and other people to look at, including social workers.
23 states have added supported decision-making as an option to their laws. Now Linda and Amy want Michigan to do the same. And Linda is already lobbying lawmakers to get changes made.
I want people to know my story, and so they can make better decisions by themselves.
SDM advocates say guardianship is still appropriate in many cases, but they hope that by making supported decision-making part of our laws, some families will have another option that can really empower their loved ones to be as independent as possible. Brian?
All right, Heather, thank you.
We go back to the presentation.
Watch this supportive decision video.
Next slide. Thank you. Who calls the shots, Linda? I do.
This is the legal opinion of Wayne County Probate Court in the matter of Linda Van Wormer. It shows, based on Linda's ability to use supported decision-making to make decisions about her life, and the support and care she receives from her family and caregivers, Linda possesses the capacity to care for herself and her estate. In conclusion, it indicates the petitioner's request for guardianship is denied.
Everyone has right to make choices.
Does that conclude?
Click on the sound thing to make this one work. There you go.
I'm Linda's brother-in-law, Brian, and part of her support network. I'm here to share why supported decision-making appeals across the aisle, because it has equity and inclusion benefits, empowerment, protects vulnerable communities, it promotes smaller government, it is family-centered, it is also cost-effective, and promotes personal accountability, as well as better life outcomes, less conflict in court, and policy alignment. So today we're asking for your support of this proposed legislation and to pass it through committee and into the House chamber. Thank you.
That's the end of the presentation.
Thank you. Thank you very much. I think that story really explained to us everything that was going on. Linda, good for you. You do call the shots. Thank you for standing up for yourself and others with disabilities. That's wonderful. And Amy, for all your help. We appreciate your presentation. Does anybody have questions? We do have more people to testify on these bills. So would like to move on? Okay, thank you very much for sharing your story. We have one question from Rep. Reingans, and then we'll move on.
Thank you so much, Linda. I am actually going to read off a comment from your state representative, Erin Burns. She's on this committee, but she couldn't be here today. She's on Zoom with you and couldn't unmute, so she wanted to make sure that you know that she really appreciates that you are testifying and empowering other Michiganders.
Hi.
Okay, thank you, Rep. Reingans. Thank you, Rep. Burns on Zoom for that support. And thank you again, Amy and Linda, for testifying. We appreciate you being here. Next, we're going to hear from Simon Zagata, the Director of Accessibility and Institutional Rights for Disability Rights Michigan.
There we go.
I think it's the cell phone. Sometimes when the cell
Might be
phone's
the
too
cell
close.
phone too close, too, so. Technology, gotta love it.
All right, thank you. Now I know for next time I'll need a phone holder, I know. Thank you all for hearing testimony on these bills today. My name is Simon Zagata. I'm the director of the Community and Institutional Rights team at Disability Rights Michigan. Here to speak on behalf of Disability Rights Michigan in support of both of these bills. My team does abuse and neglect investigations for people with all kinds of disabilities throughout the entire state. So those can be people in group homes, people in psychiatric hospitals, people in nursing homes. So we hear from disabled people who are under guardianship quite a lot. And I think it's really important to remember what it can take from people. These are some of the most fundamental decisions that we have as humans, as citizens of Michigan. Things like where to live, who to live with, what medical treatment to get, whether to take a medication or not. In some cases, we've seen the decision to sell a house or keep a house taken away from people. And these are things that can be avoided, that can remain with the person in a lot of cases with appropriate supports, like we heard a lot about today. And that's why that range of options that are in these bills are so valuable, because it does allow us, the judges, to tailor these orders more to the person instead of guardianship, which is a more one-size-fits-all approach that takes rights away. One size does not fit all. I did want to talk, because there was the question from Representative Johnson about the Michigan Probate Judges Association. There was a letter they sent opposing 4676, and I read it, and frankly, the concerns there don't make a lot of sense. The first concern they listed was about durable power of attorney and the possibility of abuse of that. Their concern is that someone will get a disabled person to sign durable power of attorney documents and then take advantage of them financially or otherwise. They say in that letter that once a person with developmental disability is found disabled, they never had capacity to enter into that arrangement. And that's just wrong. I was actually quite shocked to see that from our Probate Judges Association, because Michigan presumes capacity. We all have the capacity to make our own decisions until a court finds otherwise. And those concerns about exploitation exist in guardianship as well. We've heard the stories about people with hundreds of wards that they're making decisions for, that I know from the people I talk to, from the people I see, their guardians are not up to date on all their health information, their living situation, the details of their lives, and yet they're tasked with making these decisions. I've seen guardians sell houses to their business associates for much less than market value. That exploitation happens under guardianship. I assure you it does. And I'm not saying a durable power of attorney will never result in exploitation, but if you are competent, you can revoke that power of attorney. There are protections within durable power of attorney too. You need witnesses, you need a notary to sign off on it. So I was surprised to see those statements about someone never having capacity once they're found to be incapacitated. Those concerns exist in guardianship as well. And I think those concerns about durable power of attorney are overblown, especially because that is simply one of the options listed in the bill that a judge may order. It's not a mandate. So again, here on behalf of Disability Rights Michigan, in support of both of these bills, and unless anyone has questions, I thank you for your time.
Thank you, Simon, for your testimony. Anybody have questions? Rep. Johnson.
Thank you. Wouldn't you agree that whether it's a family member that gets guardianship or partial guardianship, or it's a guardian appointed by the court, there are always risks in having bad actors, liars, thieves, and you have the similar risk or the benefit of someone being just wonderful and taking great care of this person. None of these rules are really going to rule all of that out, but we have an oversight process that is sufficient for taking care of it either way. Would you agree that that's the truth?
Thank you, Representative, and I agree 100%, and I would add to that I think it ameliorates some of those risks to increase the power, the person who this impacts, in those decisions, because then we get to hear more directly from them and what they're comfortable with and who they want to help them.
Okay, thank you very much for your testimony. We appreciate you being here.
Thank you.
Next, we're going to have testimony from Ellen Shagru-Hyman, estate planning attorney and policy analyst. Just push the red button when you're ready to start.
Good afternoon. Thank you for the opportunity to testify, Chair and members of the committee. Some of you might know me from my health policy work, but I've also had an estate planning law practice for over 25 years and have lots of experience serving people with intellectual and developmental disabilities. As Simon alluded to, under Michigan law, everyone is presumed competent at age 18. What I always say is that I don't believe anyone's competent at age 18. Lots of bad decisions in that age group. But, you know, for everyone, whether they have a developmental disability or not, they have people around them that help them make decisions, help them what car to buy, what college to go to, what job is good. And what we want to do is support people with intellectual and developmental disabilities to have those options as well. And the biggest problem, I think, with guardianship is that it appoints one person to help them. And kind of everyone else falls off because one person's the guardian and tasked with making all the decisions and taking the person's rights, instead of having multiple people. Like you saw in Linda's example, she depends on her sister, she depends on her brother-in-law and other people. one of the reasons I'm really in support of this bill is because I've had challenges with having my documents accepted by hospitals, doctors' offices. I really tailor documents to meet the needs of the person that I'm serving. So a financial power of attorney for somebody who has only SSI and has a rep payee handling it is much different than somebody that just won the lottery and has $100 million at their disposal. One of the challenges with our law is that the patient advocate designation statute, for example, requires a triggering event. So you have to have capacity to sign the document, and then something has to happen to change that capacity. So there's some change in medical condition or a car accident, something like that. So it doesn't work to say, I'm going to sign this document as a person with intellectual developmental disability, and I want my, advocate to help me immediately. So I feel like with these bills, we could put supporting decision-making into statute, and it would be much easier to help people and support people with intellectual developmental disabilities to live full, inclusive lives in their community. Thank you for the opportunity to testify.
Thank you very much. Any questions? No. Okay, we have some cards here to read in. We have two people who have filled out cards who would like to talk in support of the bill. Let's start with Jan Lapman. Welcome.
Good afternoon. Thank you for taking me. I know that you had a limited amount of time and limited amount of people, so I appreciate being called upon. So my name is Jan Lampman. I'm actually from Midland, and I have been working with people with developmental disabilities for 40 years, and I have a sister who has a developmental disability who survived the Mount Pleasant Center, and I have two sons, one of whom has autism and the other of whom receives other kinds of behavioral health supports. They came from the foster care system. So I have some personal experience and some professional experience with guardianship. In my 40 years, I've done almost every job conceivable, including working for an agency that was a professional guardian. And I am going to tell you that was the darkest, most difficult period of my 40-year career, because one of my duties was to take someone else's rights and hold them in my hand, and then I had to make those decisions, right, on their behalf. It's so much more fun, but it's also so much more comforting to know that instead of that, now that I don't do that work, that instead of that kind of work, that I can sit down with my sister when she's just been diagnosed with cancer and pull together the people from our family that she thinks are smarter than me to help her decide what kind of medical treatment to get, right? And so when I think about not only the person that I served whose rights I was a part of taking away, right? But also the people that I've gotten to support who retained those rights and were able to live their life and make decisions in their life with the support of people that they've chosen. I can tell you the outcomes for those people that were making their own decisions have always been so much better. So that's what I would just like to share with you. I also want to share some statistics because I know stats. And Michigan, sadly, I'm very competitive. I like my teams to win. And sadly, Michigan is not winning the competition for who has more people who are engaging in supported decision-making percentage-wise of people with developmental disabilities. More than 80% of adults with developmental disabilities will end up with a guardian. That's a large number. I cannot believe that 80% of the people with developmental disabilities in our state actually require that guardianship. But when that's the only tool you know about, then that's the tool you're going to use. So let's see what we can do to increase the ability for people to look at alternatives to guardianship so that no family member has to feel like I have felt in the past, taking away my sister's rights. Thank you.
Thank you very much for your testimony. Next, we have Terry Langley, Disability Network, Michigan.
Good afternoon, Madam Chair, members of the committee. Thank you very much, and I will definitely keep this brief because I can't say too much more than what everybody before me has said. My name is Terry Langley, and I'm the Executive Director of Disability Network Michigan. And Disability Network Michigan is the collective voice of our state's 15 centers for independent living. And centers for independent living are non-residential resource and service organizations for people with any disability and at any age. The main objective of our centers is to promote and encourage and support self-sufficiency for individuals with disabilities. Centers were founded during the independent living movement and have become strong community organizations which offer resources and services. While still strongly advocate for individuals with disabilities to make their own decisions about their lives, we recognize there may be specific and very limited circumstances when an individual with a disability may need a guardian to ensure their safety and well-being. However, it is in these very specific and limited situations only. We remain steadfast in our mission to promote and support individuals with disabilities having complete control over their own lives, including medical and financial decisions, which seem to be some of the most often heard stories about guardianship experiences that have gone awry. I'm here today to share our appreciation for Representatives MacDonell and Wozniak for sponsoring House Bills 4676 and 4677. These bills include supported decision-making in the process for courts to assess whether individuals with developmental disabilities require a guardian. Centers for Independent Living are part of those supports for people with disabilities to advocate for their self-sufficiency. We have professionals on staff, most are social workers, who work with people with disabilities and make sure that they understand completely what decisions are before them, what consequences are before them, so that the person with the disability can make an informed choice of their own. And with that, I would like to say thank you again for letting me speak on behalf of Centers for Independent Living, and we appreciate your support.
Thank you for being here, and thank you for your testimony. Any questions? No? Okay, we have some cards to read in right now. These are in support of the bill. Sherry Boyd, the ARC Michigan, Sarah Carmody, self-advocate, Michigan Guardianship Association, Jeremy Murphy, Michigan Developmental Disabilities Council, Nicole Shannon, Michigan Elder Justice Initiative, Jeannie Rowe, self-advocate, Vicki Rowe, self-advocate. We do have one in opposition, and it would be the Michigan Probate Judges Association, as we heard before. Thank you, everybody, for your testimony on this package of bills. We will now move on to another package of bills, testimony on House Bill 4517, 4518, presented by Representatives Neyer and Representative Rigas. Thanks for being here.
Thank you, Chair and Committee. This bill package has been created to better enhance the Amber Alert system here in Michigan. What prompted this was an incident that happened in my district where young Rowan, 6 years old, lost his life tragically after a failed parental custody exchange. This was despite his mother's repeated warnings and attempt to get proper Amber Alert implementation. Because of the narrowness of the interpretation of the Amber Alert system way it can be implemented, no Amber Alert was implemented in time, and Rowan did lose his life. House Bill 4517 and 4518 ensure that Michigan State Police can issue an Amber Alert when they believe a child is in danger. This would also encompass more complex cases that include custody disputes and children with special needs. This bill also modernizes the alerts, how alerts are shared, authorizing law enforcement to use social media, digital platforms, and other forms in order to make outreach. At this point here, I'd like to turn it over to Representative Rigas to go into a little bit more detail on how this bill came about.
Good afternoon. Thank you, Madam Chair. Thank you, committee members, for hearing these testimony on this bill package today. This is a very emotional topic. This bill, known as the Rowan Act, would empower the Michigan State Police to activate the Amber Alert system when they believe a child is in danger. This change gives law enforcement the flexibility needed to respond swiftly in potentially life-threatening situations, putting safety above all else. I'd like to share the story briefly about young Rowan Morey to give into context why this legislation bared his name. His mother is with us today. Brandy has joined us, and she actually testified in oversight for child welfare on this very issue. Rowan was supposed to be returned after a court-mandated custody visit. So the court order was already there that this child had to be returned. Instead, for 52 hours, his mother repeatedly tried to alert authorities, but under the current Michigan law, because Rowan was missing in the context of a custodial parent rather than abduction by a stranger, the Amber Alert could not be issued. Tragically, it was only after others located Rowan that he was found after his biological father had murdered him and then killed himself. What a tragic failure. And this is just the tip of the iceberg in the failures that occurred in this specific case. But this is why we're before you today, because if this fix could have potentially not only saved Rowan's life, but custodial kidnappings are more common than we even realize. And the rate of tragedy that comes out of these situations with custodial disputes is higher than any other rate of danger for these children. So the failure of our system is exactly why the Rowan Act seeks this fix. Under HB 4518, the Michigan State Police will have the authority to activate an Amber Alert if they believe a child is in danger, even when previous traditional abduction criteria doesn't apply. The legislation recognizes that children can face lethal threats in a variety of situations, including delayed return by a custodial parent, the nuances of special needs children, and other high-risk circumstances that are invisible in today's current limitations. In Rowan's case, had his mother's concern sparked a timely alert by authorities and the court system, this tragedy could have been a different story. Today, we have the opportunity to ensure no other family must endure the gap between fear of losing their child and our state's response time. I respectfully urge you to support House Bill 4518, the Rowan Act, to empower swift, flexible protection for our children.
Thank you, representatives, for bringing this forward. And it's such a sad, tragic story, and we've heard them a lot before happening. I don't think a lot of people understand Amber Alert was just in effect for those they feel were abducted or kidnapped. And, you know, it's important that we expand that so we can protect all of our kids in these types of situations. So thank you for being here.
You're
Do we
welcome.
have
And
any-
in front of you, I did give everyone a copy of the current Amber Alert system laws. And if I can just touch on this one more, the current limitations on Amber Alert system activations, the limitations include runaway children, parental abduction involving civil custody disputes, and a child with severe disabilities who has wandered off and is capable of being located without imminent risk. So we will be putting forth amendment on this bill also to define, in the current bill, it mentions disability. We are going to elaborate on that a little bit and kind of change that language and amendment, including a missing child with a disability or disabilities. There's currently a definition of disability in statute, so that can revert back to that statute. But it's just kind of broaden that a little bit more.
Okay.
And I can take questions.
Okay, sounds good. Are there any questions from the committee? Rep. Johnson.
Thank you, Madam Chair. I have no problem with this legislation, but wouldn't you agree, or can you clarify, if the law enforcement officials get a call like this and they're deferring to what family court, case managers, magistrates, social workers, and friend of the court have already stated is the protocol, wouldn't they again say this is not appropriate for Amber Alert because the custody battle ensues and and frankly, friend of the court and the rest of the court officials seem numb to all sorts of requests for help.
So what this does, which is extremely and critically important, is under the current system, you would have to a judge would have to issue an order, and then the Michigan State Police can act and go get the child or open an investigation. What this bill does, it allows an investigation to be open immediately by the Michigan State Police, saving time.
Okay. Thank you very much, representatives, for being here. Now we're going to hear from Brandy Morey-Poles, who will talk about how much these bills are needed, and Rep. Rigas to tell us about her. Thank you for being here. Thank you so much, and of course, I'm very sorry for your loss and what you went through.
Well, first of all, I want you guys to see our son. This is Rowan. He was a really bright, happy little guy, and he golfed with us, and he couldn't wait to start his flag football season because he was going to be the best, he said.
Well, thank you. Thank you for sharing that with us. He's wonderful.
He was, yes. What Representative Rigas is telling you about is everyone in this room that has children or is a caregiver, could you imagine what you would go through in those 52 hours? I was consoling his brothers, his sisters. I reached out to every outlet I could. We were told on several occasions, it's almost impossible to get an Amber Alert. How is my child missing any different than a child snatched off the street? He wasn't. The fear, the anxiety, the praying and the pleading. I finally resorted to news, and they were going to come and interview us, but before they could get there, we found out he was gone. No child or anybody with a disability or a runaway should be denied an Amber Alert. They should get the same attention as someone taken off the street for sex trafficking. He mattered, his life matters, and all the children that come after him. That's why, along with my husband, Brian Poles, and my co-founder, Heidi Britton-Zent, created the Rowan Project to give voices to filicide. And let me inform you, I didn't even know what that word was until it happened to my son. And I heard another mother that I also work with now, Hope Mater, who lost both of her children. She said filicide. And I sidebarred, kind of looked it up. I'm like, what the heck is that? Do you realize it's the most researched word for the loss of a child? But it's the biggest epidemic sweeping our nation. And so through the Rowan Project, our first thing is to come at the Amber Alert that has not been amended in the 25 years since it's began. There are many reforms that need to be done on all levels of the system that failed my son. And let me tell you, they all did, epically. And the one thing that's made me feel so much better in this fight is hearing from Angela at the last committee telling me I was the only one who didn't fail him, even though it still feels like I did. But saving children like him from here on out will help with that, make his life matter, because it did to all of us. I had 26 hours missing. I had to file that emergency motion with the courts so the state police could step in. 26 hours. Just a few hours later, it was denied. And my son was not found by the sheriff's department. There was never an Amber Alert. He was found by family members. With this bill, Rowan's Act, if that would have been in place before my son went missing, anything like it, it wouldn't have just possibly saved him. It would have. It would have. I don't want another parent or caregiver to sit for 52 hours wondering where their child is with no communication, no nothing. I stopped myself from thinking the worst because he was doing it for me. I had hope up until I walked in my home and saw my pastor, my parents, my husband crying, my children crying, and 8 other Kent County sheriffs when I fell to the floor screaming. that full metal wall of pain that took me to the floor. I don't ever want another person to feel that, and help me make this come to fruition and save kids. There shouldn't be limitations on an Amber Alert. It shouldn't be difficult to get. It shouldn't be this hard. What's the hurt in if you put an Amber Alert and they're found, or it wasn't really a child that was missing? There's nothing wrong. They're not that busy that they can't issue something like this to save our children. So help me do that. Save more kids so Rowan's life matters. You want to say something?
Yeah. I haven't really spoken about this a whole lot because I'm a guy and I have to try and be strong for her. But I do have one comfort with Rowan, in that he loved his mom and dad unconditionally. He never thought his dad would hurt him. He was an amazing kid. Kids love unconditionally. They love their parents. And knowing that a parent can do that to a child, which after 15 hours of Rowan missing, I stood face to face to an Isabella County sheriff and told him that I am in fear for a murder-suicide because of what we have witnessed with Rowan around us. Only to find out that what I said exactly came true. So I really feel that we need to show every kid unconditional love and do everything we can to protect them, even from parents at times. And it's a very difficult decision to decide which parent is being truthful, which one is being manipulative, but we still need to put the kids first, because kids can't defend themselves. This 6-year-old can't defend himself against a parent, and that's where he needs help backing him up and defending him. So that's my big push, and that's all. Thank you very much for your time. I really appreciate it.
I can't thank you enough, both of you, for being here. I can't even imagine how terrible this is and what you went through, and I'm sorry for that. And don't ever feel like you failed your son. You have not. You have not. You are doing so much now to save so many kids. So thank you so much for being here. Do we have any questions? Thank you again. And anything we can do to help you out, please let us know.
We appreciate it. Thank you.
Next, we'd like to call up a couple people who'd like to talk in support of this bill. Victoria Jones is next. Just to let everybody know, we do have to break at 1:30 for a session to start, and then we'll start up again.
Okay, thank you. My name is Victoria Jones. This was our son, Jermaine. He passed away in October of 2023. So I appreciate the ability to come here and speak, as is. My name is Victoria Jones. I came here to tell you guys my son's story. A few of you guys might already know it, but I think the weight of Jermaine's story is more clearly conveyed through the eyes of the woman who gave birth to him. I could ramble on hours and hours about how great of a soul my son was and how different our world became the day he died, so I'll try to stay on script. In October 2023, I got a call from my children's father. He was frantic, telling me our youngest son, who was a month short of turning 3 years old, was missing. The babysitter had showered and forgotten to lock the door, and at the time of his disappearance, my son had been in classes for all his autistic symptoms for months by this time. Wandering was something we had heard about and even experienced. A month before his death, he had gotten out, similar situation, but he was found within an hour. October 9th, 2023, it was not the same case. By the time I had driven 3 hours from my home in northern Michigan to my son's father's house in Wakusta, the country roads were lined with vehicles, people walking, searching. You'd have thought it was like a parade. There were so many cars around the roads. I had strangers walking up to me, showing me pictures of my own son, asking if I had seen him because they were just trying to spread the word. Unknowing to them, of course, it was my kid. That was the longest night of my life. I can still hear helicopters in the back of my brain. Excuse me. And the recording I made on a drone that played over and over again in hopes that he'd hear it and come out of hiding. I watched dive teams search any body of water that he nearly could have found in the area. None of that ever stops replaying in my head. Can't hear a helicopter now without completely falling over. After his body was found in the Looking Glass River on October 10th, multiple people came forward, postal workers, Amazon drivers, random members of the community. And they all said they seen my son walking down the road in short snowshoes and a sweatshirt in October. And they knew no better than to stop and help him. They just kept going. There was no alert sent out to their personal or work mandated phones. Why? Because the criteria wasn't met. In order to send out that message, that day I lost a huge part of myself. I felt a pain I didn't know was possible. My son drowned, and for the last 659 days, I felt like I've been drowning above water. These children are arguably the most vulnerable part of our population, and they deserve nothing but the highest level of protection. There has to be a change. Every single day is just another day, right? Any day, this could be just another day for another child to lose their life. October 9th, 2023 was just another day for all of you. For me, it was the worst day of my life. And today could be the worst day of another parent's life simply because this law isn't passed. Like the former mother had said, what is going to hurt from just a law, just a text being sent out? It's not going to hurt anybody. Our son would still be here. He 100% would still be here if that alert had been able to go out. My son's gone. I'm never going to see him again. He was nonverbal. I'll never hear him say my name, and neither will Brant. And as a mother, I'll do anything and everything in my power to keep any other mother from feeling the pain that I feel every single day when I wake up and when I go to bed. And when I look at my second son, who is almost 8 years old, and he looks just like his brother. His little brother was a spitting image of him. And this is very important. These children deserve this. They need this. And the pain that I feel, the pain that she feels, the pain that so many parents and loved ones have to feel all the time simply because of something so small. I really just hope you guys consider the pain and the things we go through, and I appreciate you listening. Thank you.
Thank you so much again. I'm so sorry for your loss, and this is something we have to take care of. We know that, and I just can't imagine what you're going through. But we will fix this and save a lot of lives, and know you being here help us do that. So thank you.
We really appreciate it, guys.
Thank you. We have one more person to speak, Kimberly McCurry.
Please, I want to.
Kimberly, are you here?
Yeah, absolutely. Please, I would love that.
Okay, we do have to break at 1:30, so.
Try to keep it short.
Okay, thank you.
He tagged along
Oh, we
today.
have
He
to?
bumped his head last
Okay,
night.
I'm sorry, we have to go at ease right now
Oh.
to start the session, and then we'll start up again, okay?
How much longer? Or?
The committee will be adjourned if, go at ease. Committee on Families and Veterans will come to order. Right now, we will hear from Kimberly McCurry. Thank you for waiting for us to start again. Just push the red button.
Okay.
Red button.
Thank you for allowing me to testify today on behalf of the House Bills 4517 and 4518. My name is Kimberly McCurry, and I wanted to share how I became involved with actively working on updating the Amber Alert in Michigan as part of the current bill's proposals contain the special needs update I was working on prior, and why I want to make sure Jermaine Jones' story that you heard about earlier is not forgotten. On October 9th, I saw a friend posted they were going to search for a toddler that wandered off 4 hours earlier in Wakusta. Having young children myself, my empathy immediately hit, and a big lump filled my throat. What were the parents feeling? As the day grew on, more details emerged. The boy's name was Jermaine Jones. He was a nonverbal autistic child, which was concerning as they tend to be more drawn towards water than neurotypical children, and the Looking Glass River was nearby. As day grew into night, I began wondering what Jermaine was feeling. I'm scared, I'm cold. Where's mommy? Where's daddy? My heart was breaking for him. And then at 4 a.m., my own daughter, who I would find out was only 5 days older than Jermaine, woke up screaming, "Help me, help me," and immediately went back to sleep. Yes, it was probably a coincidence, but my husband and I both wondered, why was she receiving a message? The gut-wrenching feeling we had. What could we do? How could we even explain it when he was found the next day? We had to wonder, was he there the whole night, or did he fall in the early hours of the morning? The big factor in this case is he had been seen by 3 to 4 people wandering the road, but was overlooked. No one stopped. There was no alert. Why would they? And many ended up asking, why wasn't there an alert? This is why I got involved. I cried every day for this child until I submitted the bill I worked on to my state representative by what would have been Jermaine's 3rd birthday in November of 2023. Last year, former Rep. Filler was able to introduce House Bill 5919 to update the Amber Alert to include special needs children. It didn't even make it to the hearing stage. As he exited, I asked if he knew who was picking up the bill and if he could pass my name forward, and he said he would. I didn't receive any calls from any other representatives, though, and life pulls you in other directions for a while. But as soon as I saw House Bill 4518, I immediately reached out to Representative Rigas' office. There was 2 things on my mind. Thank you. And I don't want Jermaine Jones to be overlooked again, especially when he had been such an inspiration, at least to me, which is why I felt I had to speak on his behalf. When I began writing the bill, I reached out to Jermaine's family to use his name, and I could not see his name being forgotten that easily. I would like to request the act be named the Rowan Jermaine Act, as this act would have saved more than one victim in the past 2 years. In addition, the bill that I submitted actually contained more beyond the special needs. It could have actually saved Rowan. And it also covers minors with significant health issues that require timely medications and minors under the age of 8. In conclusion, I am here to support these bills because they need to pass with or without the suggested changes. Since Jermaine's death, there have been at least 105 other autistic children that have wandered off and drowned nationwide. And I just found out about this hearing just last week, so I was not able to conduct all of the research I wanted to. But in the past 3 months, there have been at least 3 cases in the nation where the non-custodial parent murdered their children since Rowan's death. So I am here to support these bills.
Thank you very much for your testimony. And again, sorry for the loss. I just can't imagine going through, whether it's friends, family, your own. It's just amazing that we don't have more protection for our children. And it's due time that these bills came up, and we'll get it through committee, hopefully our next meeting, and get it to the House floor as soon as possible. Thank you so much for taking the time out and for babysitting too at the same time. We appreciate you being here, and if anybody has any questions, I think we're good. Thank you again, and we will make sure that we get something passed here. Thank you. Rep. Wozniak moves to excuse absent members.
We actually can't excuse absent members without a quorum. I apologize.
Okay. Guess we can't do that without a quorum, so we will not excuse absent members. Sorry, Rep. Wozniak. Thank you. There being no further business for the committee will stand adjourned.